A convicted offender walks back into a church, not to sit quietly in the back row, not to seek forgiveness in silence. He walks back in, and they hand him a title. They give him authority. They give him access to minors. And for 4 years, nobody stops him. This is not speculation. This is not rumor. This is a civil lawsuit filed in King County, Washington, backed by court records, arrest documents, and the testimony of 4 men who were young members when it happened. And what this case reveals is not just the failure of one congregation. It exposes a system, a structure of authority, silence, and legal maneuvering that critics say was designed to protect the institution, not the youth inside it. By the end of this video, you will understand exactly how a man with a documented criminal history was not only welcomed back into the LDS Church, but elevated to one of its highest local positions. And you will see why the people suing the church say the real failure was not just what he did, it was what the church allowed him to do. Part 1. The Conviction. In 1993, David Herget was a high priest in the Mountlake Ward, a congregation of the Church of Jesus Christ of Latter-day Saints in Mountlake Terrace, Washington. That year, he was convicted of serious transgressions against a 13-year-old family member. The court sentenced him to 7 years. He served 180 days. According to the lawsuit, senior church members wrote letters advocating for leniency during his sentencing. While the specific names are redacted in the public civil complaint, the filing states these claims are based on the 1993 sentencing records. This is not just an allegation from the survivors. It is a matter of judicial record that the institution intervened at the very start. After his release, Herget was placed under state supervision. He was a registered offender. His history was documented. None of this was hidden. And yet, before his supervision even ended, the complaint alleges he was attending church services and actively participating in the Mountlake Ward. Not in some anonymous capacity. He was given a calling, a church responsibility, that involved printing and distributing programs during Sunday services. A task that, according to the lawsuit, required him to recruit young members to help at his home. The church, the complaint states, was aware of this arrangement. And here is the question that will come back in Part 3. If the leadership knew his history, knew he was working with youth and said nothing, what does that say about the system they operate under? Part 2. The Reinstatement. In 2002, David Herget was rebaptized into the church. The excommunication was reversed. The slate, at least in institutional terms, was wiped clean. 2 years later, in 2004, his authority as a high priest was formally restored. In the LDS Church, the restoration of blessings for someone excommunicated for a serious transgression is not a local decision. It requires a formal application and the specific approval of the First Presidency in Salt Lake City, the highest governing body in the entire church. This means the system did not just fail at the ward level, it failed at the very top. This is not a minor title. In LDS theology, the Melchizedek priesthood, of which high priest is an office, represents spiritual authority. It carries weight, it carries trust. Parents in the ward would have understood that title to mean something, that this was a man the church had evaluated, accepted, and endorsed. But during this same period, between 2001 and 2005, the lawsuit alleges Herget was systematically targeting youth in the ward, 4 minors. The youngest was 5 years old. The methods described in the complaint are consistent across all 4 accounts. Herget allegedly created specially designed programs with candy taped inside that he distributed exclusively to young members. According to the filing, he did this in plain view of the ward's bishop and the stake president. He was permitted to dress as Santa Claus during holidays and have young members sit on his lap. He invited youth to his home under the pretext of helping with church tasks. He used video games as a lure. He used his position of authority to create trust and isolation. The legal complaint centers on 2 specific claims: negligent retention and negligent supervision. Negligent retention means the church kept Herget in a position of trust even after his documented history made it clear he posed a danger. Negligent supervision means the church failed to monitor or restrict his access to minors despite knowing the risk. These are not abstract accusations. They describe institutional decisions, decisions with signatures, with approvals, with a paper trail. One account describes a 5-year-old who was too sick to attend Sunday services. Herget allegedly visited the minor at home, ostensibly to deliver the candy program he had missed. The minor was left alone with him. That individual is identified in the lawsuit as John Roe number 2. Another plaintiff, John Roe number 3, alleges the pattern of misconduct took place on church property itself, during Sunday services, in rooms adjacent to the sacrament hall, and in Herget's home, from age 11 to 15, for 4 years straight. On July 2, 2005, Mountlake Terrace police arrested David Herget. He faced 18 criminal charges. The safety protocols had failed to protect the youth in the ward for years. He passed away while in custody at Snohomish County Jail. He never faced trial. The 4 survivors are now adults. They live in different states. And 20 years later, they are suing the Church of Jesus Christ of Latter-day Saints. Part 3. The system. This is the part of the story that matters most. Because if this were simply about one man in one ward, it would be a crime story. It is not. It is a system story. The lawsuit centers on negligent retention and negligent supervision. It argues that with a centralized structure and assets exceeding $250 billion, the failure to implement a professional background check system for every calling is not a lack of resources. It is a choice of priorities. The organization owns the protocol, so it owns the outcome. And as we saw in Part 2, the decision to restore Herget's priesthood required First Presidency approval. Someone reviewed his file. Someone signed off. The question is not whether the institution knew. The question is how high the knowledge went. And the evidence suggests it went all the way to Salt Lake City. This is where the Mountlake case connects to a much larger pattern. In 1995, the LDS Church established what it calls a safeguarding helpline, a phone number that bishops and stake presidents are instructed to call when they receive reports of misconduct involving minors. On the surface, this sounds responsible, a centralized system, a protocol. But investigations, including a major report by the Associated Press, have revealed something troubling about that system. The helpline is not staffed by social workers. It is not staffed by safeguarding specialists. It is staffed by attorneys from Curtin McConkie, the church's primary defense law firm, the same firm that represents the church in related litigation. According to that investigation, calls to the helpline were routinely classified as attorney-client communications, shielding them from disclosure. Records of calls were allegedly destroyed at the end of each day. Bishops who reported misconduct through the helpline were, in some cases, advised not to contact law enforcement, even in states where clergy are legally required to report. The most well-known example is the Paul Adams case in Arizona. In 2010, a bishop in Cochise County learned that a father in his congregation was harming his own daughter. The bishop called the helpline. A Curtin McConkie attorney, who also happened to be a state legislator, allegedly advised the bishop not to report. The pattern of harm continued for 7 more years. It was federal authorities, not the church, who eventually intervened in 2017. Now consider Mountlake. The lawsuit does not specifically reference the helpline, but it asks a structural question that is central to every case involving the LDS Church and institutional safeguarding. When leadership at the local level knew about David Herget's history and still gave him access to minors, who else in the institutional chain was informed? And given that restoring his priesthood required First Presidency approval, who reviewed his file, and what did they choose to ignore? In April 2025, the LDS Church agreed in principle to settle more than 100 related lawsuits filed in California. It was the largest known resolution in the church's history. Courts in multiple states are now granting plaintiffs broader access to internal church documents and helpline records. The legal landscape is shifting. The LDS Church operates under a centralized, top-down authority structure. Unlike the Catholic Church, where individual dioceses can declare bankruptcy to limit exposure, the LDS Church functions as a single, unified institution. When the organization dictates the protocol, call the helpline, consult the attorney, wait for instructions, the organization owns the outcome. 4 minors in a small ward in Washington state trusted the adults around them. They trusted the man with the title. They trusted the institution that gave him that title. And for 4 years, that trust was used against them. David Herget has passed away. He will never face a jury. But the institution that reinstated him, promoted him, and gave him unsupervised access to minors, that institution is still operating, still issuing callings, still directing bishops to call the same helpline, still claiming the mantle of divine guidance. The LDS Church teaches its members that bishops and stake presidents operate under a gift called the spirit of discernment, a divine ability to perceive truth, to detect deception, to protect the flock. If the spirit of discernment failed to protect the most vulnerable in the rooms of their own chapel, we have to ask a harder question. Is this divine gift meant to protect the flock, or is it a tool used to protect the reputation of the institution? If this story resonated with you, I need you to do two things. First, share this video. Cases like this do not get national attention unless people push them into the conversation. Second, subscribe and turn on notifications because we are tracking every major lawsuit, every settlement, and every internal policy change as it happens. The Mountlake case is one of dozens moving through the courts right now, and when new filings come in, you will hear about them here first. Drop a comment below. Tell me what you think about the church's responsibility in cases like this. And if you are a survivor, know that your story matters, and you are not alone.